Hey everybody, welcome, welcome to Hidden Horror. Thank you for spending this time with me. I appreciate that. Let's get started. Hey everybody, welcome to Hidden Horror. I'm here today to talk to you about Bryan Kohberger's alibi. It's back on my brain again. And I was kind of concerned about the alibi, but once I started learning a little bit more about some of the Idaho laws, I think that the way that the Idaho law is set up, we're going to talk about is Rule 406. I think that his alibi can be submitted because he's shown it to be a habit, something routine that he does. So, again, I want to go over something that was an emotion. So, I'm going to share my screen. Some time ago, back in, I think it was about August of 2023, there was a motion that was filed. Um, and it was basically trying to compel Bryan Kohberger to provide an alibi because, as we know, that alibi has to be very specific. It has to show locations and witnesses that will be able to testify to the whereabouts of the person. But I found something in the Idaho Code that's not necessarily, as long as you can demonstrate that it's a habit, that it's a routine, you don't have to have anybody to testify to your alibi. So let's go over this information again. What I'm showing you now is the Hidden Horror Facebook page, and back about August of 2023, I shared this objection. And it was just a motion to compel more details about Bryan Kohberger's alibi. So I'm showing it here. If you want to read it again, you can check it out. It's posted on the Hidden Horror Facebook page, but you have to go back to August 7th of 2023. But we're not gonna go over it all. Okay, that's what it's called. So Idaho Code 19-519 and ICR 12.1 require an alibi disclosure of a specific location with a specific location and witnesses to testify. By statutory definition, Mr. Kohberger may remain silent yet testify that he was not at 1122 King Road on November 13, 2022. However, in abundance of caution and recognizing the court has authority to exclude witnesses, it's out of order. Am I missing something? Let me see. I'm missing the bottom of it. Mr. Kohberger. I'm not going to read that big caption. So we're going to go down to page 2, and it reads, Mr. Kohberger has long had a habit of going for drives alone. Often he would go for drives at night. And let me go to the second page so you can see where I'm reading from right here, okay? I don't want to enlarge it too much because it's going to cut off the bottom. But I'll continue. Often he would go for drives at night. He did so late on November 12th and into November 13th, 2022. Mr. Kohberger is not claiming to be at a specific location at a specific time. At this time, there is not a specific witness to say precisely where Mr. Kohberger was at each moment of the hours between late night, November 12th, 2022, and early morning, November 13th, 2022. They're really honing in, excuse me, on the time frame between 2:47 a.m. and 4:48 a.m. That time frame specifically on November 13th, 2022. Excuse me. I'll continue. He was out driving during the late night and early morning hours of November 12th into November 13th, 2022. Counsel for Mr. Kohberger is aware that case law broadens the definition of alibi with the statutory requirement of a specific location to more broadly include disclosure of information that tends to state the person claiming alibi was at a place other than the location of an offense. Mr. Kohberger has complied to the extent possible at this time. And then it reads corroboration of Bryan Kohberger not being at 1122 King may be brought out through cross examination of the state's witnesses. At this time, Mr. Kohberger cannot be more specific about the possible witnesses and exactly what they will say. The defense has been hampered by the state's own choices. The state chose a secret grand jury rather than the planned preliminary hearing. Had the state moved forward with the preliminary hearing, the defense would have the opportunity to develop testimony through cross examination and witness presentation. Okay. Um, let's we'll be done with this, okay? But you can check out the entire um objection when you have time because we're going to move forward. That's not even the focus. The focus is there is a rule, it's called Rule 406. And this is how I think they're going to be able to get the alibi in. So let me share my screen. Okay. Okay. So we're on the Supreme Court for the state of Idaho Judicial Branch. And they have a rule, it's Rule 406, and it's referring to habit and routine practice. And this is how I think they're going to get the alibi in without having any corroboration or eyewitness or anything like that. They won't need it because they're trying to demonstrate through Bryan Kohberger's history, his records, his habits, again, routines that he typically did the driving, he did the stargazing, watching the moon, taking these photographs. And they'll be able to demonstrate through the months leading up into the murders on November 13th, 2022, that this was a habit. This was something that Bryan Kohberger routinely did for jogging, running, etc. Okay, so this is the rule. It's Idaho Rules of Evidence, Rule 406, and it reads: evidence of a person's habit or an organization's routine practice may be admitted to prove that on a particular occasion, the person or organization acted in accordance with the habit or routine practice. The court may admit this evidence regardless of whether it is corroborated or whether there was an eyewitness. So, what I am thinking, and Taylor has formulated Bryan Kohberger's alibi in such a manner that she's going to demonstrate and be able to show that this was a habit, this was a routine, this night driving, this running, this stargazing, etc. And that if she goes under the Rule 406, he will not need this corroborated. He will not need to provide an eyewitness, and he will still be able to have the alibi submitted into evidence. Now, I wanted to share this article with you because someone that was pretty savvy, they realized this, and there was an article that came out about it. Okay, so I'll leave that up as I read through this information. So this article is coming from newsweek.com. It's dated August 4th, 2023, and it's titled Bryan Kohberger's alibi contains two significant terms, criminal attorney. And this is by Gerard Kayonga. Now, it says, Murder suspect Bryan Kohberger's alibi has been dissected by a criminal attorney who indicated it contains two significant terms. Kohberger, 28, is the sole suspect in the quadruple killing of Kaylee Gottclaves, 21, Madison Morgan, 21, Xander Canova, 20, and Ethan Chapin, 20. The prosecution has said that Kohberger broke into the student's home in the early morning hours of November 13th and fatally stabbed each of the victims. The latest court documents filed on Thursday have Kohberger's attorney trying to stop it. Excuse me. The latest court documents filed on Thursday have Kohberger's attorneys claim their client was out for a drive on the night in question and was alone. It added that Kohberger would regularly go for solitary drives. His defense lawyers entered a not guilty plea on his behalf back in May to the 4 counts of murder and 1 count of burglary connected to the investigation. Kohberger was a PhD criminology student and teaching assistant at Washington State University's campus at the time of the killings. Criminal attorney Sarah Azari spoke to News Nation's Brian Enton on Thursday and reflected on the suspect's alibi. She explained why the points raised in the alibi that Kohberger was allegedly alone and driving around were significant. Enton remarked that he expected a more significant and in-depth alibi to come from Kohberger's defense team at this point. I am sorry you are disappointed, but look, Kohberger's attorney, Ann Taylor, is all business. She is no games here, Azari said. I think we are used to seeing an alibi in the traditional sense where it is, I was here at this time and these are the people who can corroborate it. This is not what she is doing. What stood out to me is that there is this new information and we know that she is saying he was alone. Translation, there is nobody that corroborate where he was, what he was doing at this time, and that he was driving around. That is key because should those cell pings, the movement of the car, the data from the phone, in fact, check out and be reliable forensic evidence, then he doesn't have to deny it was him driving. He could just say that it's still insufficient to place me in this party house and put a knife in my hand. So I think those two terms were really significant in terms of the new information. A trial for the case has been tentatively set to start on October 2nd. So again, as I've said, and I want to just review one more time, Idaho Rules of Evidence Rule 406 pertains to habit and routine practice, okay? It means that Bryan Kohberger neither needs to have anyone corroborate his alibi or have an eyewitness to him to say that they saw him because he has laid the foundation saying that he was out driving, something that he routinely did. He'll be able to demonstrate that, and he'll be able to show a routine, a history, a habit of doing these night drives, taking pictures, and stargazing. That's my opinion. I was thinking about the alibi, trying to learn more, and I think this is how he's going to be able to get the alibi admitted by using Rule 406, okay? Let me know what you think. Just my thoughts. I'm working hard for you, okay? So please put in the comments, what do you think about it all? Please, no, I'm interested, okay? Thank you for spending this time with me. I really, really appreciate it. I want you to stay smart, stay savvy, be well, all my friends. Bye, everybody.